Hey, hi everyone. Thank you for joining us for today's webinar. My name is Beth Cohen King, and I'm the Marketing Director at Margolis & Bloom, and the moderator for today. So just a little background about Margolis & Bloom. We work with our clients to find the best estate planning or elder law solution for each client's unique situation and goals. We bring to this effort 30 years of experience and a commitment to providing the highest level of personalized service. So, today we are doing a Q&A with Sarah Hartline, who's a senior associate at M&B. This will also provide a general overview of estate planning basics, which I think we all need. A little background about me: I'm also a fairly new parent with 2 young girls. So when Sarah and I were talking about this, I was thrilled that she wanted to answer not only my questions, but questions she routinely sees. So just a few housekeeping items before I pass it over to Sarah. You can use the question panel you can use the question panel on the right side. So throw in a question if something comes up. We'll do our best to answer in real time, and if not, Sarah will follow up afterwards. And there's our mugs, and then we're gonna now I'm gonna turn it over to Sarah.
Great, thank you. Good afternoon, everyone. As Beth mentioned, I'm an estate planning attorney here and also the mom of 2 young kids. And we were actually talking earlier today about how overwhelming it can be to try to get your estate planning done when you have young kids because, first of all, definitely not something you want to talk about or think about. Second, we constantly, both of us, and I'm sure all of you do, have a to-do list of about 100 things that we need to get done. Getting new clothes for our kids because they somehow have already outgrown the clothes we bought 2 weeks ago. Whatever it is, buying a new car seat, it seems pretty constant. Beth's kids are a little bit older than mine, but I get the feeling that it's not really never ending. And I think a third thing is that we often get overwhelmed when people start talking about trusts, probate, fiduciaries. The terminology can be confusing and we feel overwhelmed, so we just don't do anything at all. So I'm hoping that this webinar will be helpful in that it will educate you on some of the basics so that the terminology will make a little bit more sense, and then, as Beth mentioned, go over questions that either we commonly hear or questions that people have emailed to us in advance of the webinar. So the first question, or I should say, just to give a brief overview of what is estate planning. Your estate is all of your assets, so your bank accounts, your real estate, your car, personal tangible property like furniture, those things all make up your estate, and estate planning is the process of planning how you will pass on those assets to others after you've passed, or even in some cases while you're still living. And some of the goals that people have coming into estate planning might be, for example, ensuring that the right people receive those assets, leaving them in a way so that the beneficiaries can get the maximum benefit from those assets, minimizing estate taxes involved in this process, avoiding probate, which is something I'm going to talk about in a few minutes, and then designating people to care for and make decisions for your children if you're unable to do so. But estate planning is also about designating agents to make your healthcare decisions and financial decisions while you're still living. So I am going to start by just talking about healthcare. One of the 2 basic documents that are most important when you're still living, which is the healthcare proxy. And healthcare proxy is a document where you appoint an agent to make healthcare decisions for you if you're unable to do so yourself. So if you are in a hospital, for example, if there's an accident and the doctors need someone to make a decision, this document says exactly who that person should be, and it can also include what's called a medical directive in that document, which would be specific instructions that you have on what type of care you would want to receive. So healthcare proxy, obviously very important for really anybody over the age of 18 to have this document in place. And another document that we prepare along with the healthcare proxy is what's called a HIPAA release. And that HIPAA release gives access to the healthcare agents or other people that you appoint in the HIPAA release to access your medical records. So those two are very essential documents, and I have here what the alternative is. If you don't have these documents in place, often the court might need to get involved and appoint somebody as your guardian for purposes of making these decisions. Obviously, that's a time-consuming, expensive process, and ultimately, the person that's appointed might not be the person that you really want.
So in this situation, does the HIPAA make it so that the physician has to provide that information versus a durable power of attorney, which I think you're going to talk about later, but does this sort of give that all access pass?
Yes, so the HIPAA release is an all access pass, and it does apply regardless of, there doesn't need to be any sort of finding of incapacity. So if you give your spouse, you appoint them under your HIPAA release, you name them in that document, they can at any time call a doctor's office or talk to a doctor at a hospital and get information, very personal information about you. So it's definitely something that you have to be careful about who you appoint in it, but in certain situations, it might be really important that they can get that information. So the other important document that really applies while you're still living is the durable power of attorney. And that is similar to the healthcare proxy in that it's appointing an agent to make financial decisions for you if you're unable to make them yourself. So if you're incapacitated, for example, and someone needs to go to a bank, access one of your bank accounts to, for example, pay for a hospital bill, the power of attorney would allow that person to go into the bank, to access the funds, to obtain bank statements, any type of financial information about you would be available to that person that's named under your power of attorney. We typically do a durable power of attorney versus a springing power of attorney, and the difference is that a springing power of attorney only becomes effective upon your incapacity, whereas a durable power of attorney is in effect as soon as you sign it. So the reason why we do that is that you don't want to be in a situation where you, for example, are going to a bank trying to get access to, for example, a spouse's information, and they're requiring you to provide medical documentation to show that the person is incapacitated. It can be very cumbersome and slow down the process. So the durable power of attorney is effective right away. But again, just in terms of making this decision, you have to be careful. Hopefully you trust your spouse, but if you are appointing somebody else, like a friend or other family member, that person is going to automatically, as soon as it's signed, be able to go into a bank and withdraw funds on your behalf.
Oh, okay.
And again, here I have just the alternative, which is something that we also see a lot of in this practice, is that when somebody does not have a power of attorney and unfortunately they do become incapacitated, the alternative is that whoever it is, the children or other family members that are coming to us, do have to go to court and obtain a conservatorship. It's a very time-consuming and stressful process for the family, and also it can be difficult because, for example, if there's multiple children, it's unclear what person, what child should be appointed in that role, should be making decisions, because the person never had made any has no documentation making that decision. So certainly something that's important for everyone.
So mainly it probably would be your spouse or somebody that you trust. In the children situation, that's maybe when you're revising your documents later, because with young children, you're gonna, obviously, you're not making any decisions for you.
Right, exactly. So I should clarify, yes. Most of the time when somebody is appointing a child, for example, as their in their power of attorney, it's because their child is an adult.
Okay. Do
yes.
they have to be over 18 in order to have that?
Yes, you would not want to appoint a child in any type of role as a fiduciary. So we often have we often have people that come in and they might appoint friends or family members as their they would appoint their spouse as the primary and then appoint a friend or a family member as an alternate. And then once the children are grown, they might come in to revisit their plan, revise it. In most cases, that's 20 years later anyways. So it makes sense to take another look at their plan. And at that point, if they're comfortable, they might decide at that point that the children should be appointed in those backup roles. So the third estate planning document I'm going to talk about is the will, which is probably the one that most people are most familiar with. And this is the document, any type of property that you have that is not in a trust, any property that doesn't have joint names on it. So for example, real estate is often owned jointly between spouses. So when the first spouse passes, the real estate is automatically owned by the surviving spouse. So that actually passes outside of that first spouse's will. But property that's just in your individual name, so stocks that are in your individual name, bank accounts in your individual name, those are going to be distributed based on the instructions in your will, which says this is how my property should be distributed. And it also puts somebody in charge of your estate, which commonly called the executor, but in Massachusetts it's actually called the personal representative. But that's the person that's in charge of your estate. And the will can also name a guardian for minor children or an incapacitated spouse. So you can nominate a certain specific person that you would like to serve in that role. The fourth thing that the will does is that it also can give people access to your personal information. So although you might have a power of attorney or a healthcare proxy, after you've passed, those documents no longer are going to have any effect because that's when the will is now taking over. So the personal representative or executor would be able to access information, any types of personal information about you using the letters of authority that would be issued by the court. So the last document before we get to the questions is a trust. And the confusing thing about trust is that there's so many different types of trusts that it's hard to, often people think if I have a trust, then, for example, the property is protected, or if I have a trust, then nobody can access the funds. There's so many different types of trusts that it's hard to speak generally about them, but there are some basic reasons especially for new parents, why they would want to incorporate a trust into their plan. The first is that it would provide terms on which property is going to be distributed to your children. So especially if they were in the unlikely event that they are minor children when you were to pass. So if you don't have a trust, then at the age of majority, at 18, the child is going to normally have access under the will to all of the any sort of property that you leave them. But if you incorporate a trust into the plan, you can say that upon reaching 18, they might not have access to any of the assets. Instead, there's going to be a trustee in control, but they will be able to be accessed, for example, a certain percentage. Often we see like a third of the property when they reach the age of 25, and then a half of the property when they reach the age of 30. Whatever types of ages or terms that you want to put into that. So that's usually, most people don't want their kids to be able to access everything at 18. So that's why often a trust is involved. Another advantage to using the trust is that it avoids probate. So that process that we were just talking about, where you have to file your will and have an executor appointed and the will allowed, if you use a trust, you can put assets into the trust while you're still living, and then the trustee can immediately use those assets upon your passing. You don't have to go through that court process. That's a major benefit to a trust. The other two advantages are that in Massachusetts, the estate tax threshold is $1 million. So often, especially if you own property in this area, you can get over that $1 million threshold and want to use a trust in order to minimize the estate taxes. I won't go into the details, but I'll just say that that's something that often people use as a tool. And then finally, a trust is often used, as I mentioned, you can put assets into the trust while you're still living, and people will often use them as a way of providing for management of property while they're still living. So for example, if they do have real estate, they transfer it into the name of their trust, and then the trustees can make decisions, act on behalf of the trust. And so that's one way that people, especially if there's real estate involved, they find that helps to ease the management of that property.
So do you think with the, because of the prices of homes in this area, if you and your spouse are both on the deed and you own the property, does that mean that individually, so say it's 500,000 each or whatever, if you're past that million, or 501 each, does that mean is it thought of individually, or is it thought of as a joint tenant?
I see. So good question. So should you be looking at your half of the assets, or I think, is that the question, or should you be looking at your assets together? So so the thing about the Massachusetts estate tax is that when either spouse passes, there's not going to be any sort of estate tax, because spouses have an unlimited exemption from estate taxes. So even if you have $3 million and you pass it to the surviving spouse, that surviving spouse is not going to be paying any taxes, even if your half has over $1 million. But when the surviving spouse passes and the property is being passed down to the children, that's when the tax comes into play. So if you pass, in that your example, $500,000 to the surviving spouse, then the surviving spouse now has $1 million because they have the $500,000 they started with, and then $500,000 that you pass to them. So that's when the tax would come into play. Is when the property is then passed on, for example, to the children. If it's over $1 million, it triggers that estate tax. And an important thing to know is that in Massachusetts, unlike some other states, if you're at $1,001,001, you're not just, that $1 is not just getting taxed. The entire $1,001,001 gets taxed. So so that $1 can make a big difference. So so that's one of the reasons that people use trust, because it all has to do with how you can protect assets upon one spouse's passing, by, instead of having them go directly to the surviving spouse, having them, for example, go into a trust.
Okay, so I think it's time to jump into some more detailed questions.
Okay.
Again, anyone, if you have questions while this is going on, please put them into the question panel, and we'll go from there. If there's
yes,
more.
And if there's questions that we can't get to, like Beth mentioned, I can definitely send you an email as well.
Sure. Okay, so when is the best time to do an initial plan? If you have more than one kid, is it easy to make revisions?
Right, so this is a common question, because sometimes, for example, you have one child, and then the thought is, do I have to wait until I'm finished having children to make my estate plan? Because I don't want to leave everything to the first child. So the way that if you do have minor children, the way that most estate planners will draft your plan is, instead of just naming specific children, they'll just say, I leave my property to my children equally. Usually it's, if the surviving spouse, if the first spouse has passed, but if my spouse has passed, then I leave the property to my children in equal shares. And so certainly you can make it clear to your estate planning attorney that you don't want to have people named individually because of the fact that you might be having more children. So I don't think that is a reason not to do an estate plan. I certainly would recommend that once you are expecting or have a child, there's no reason to wait, and it's definitely a reason to, like I said, in the very unlikely scenario that something were to happen to you, you do want to have, this is the person that I want to step in as guardian. You do want to have those wishes in writing, and also, even if it's a very basic plan, it's better than doing nothing. I always like to say, don't let the perfect plan come in the way of doing any type of planning. So maybe you only get your healthcare proxies and your powers of attorney done, but that's still better than not doing nothing.
So what if you don't have a large estate currently, but both spouses are working, you anticipate future growth?
Sure.
We're on the upward trajectory, hopefully.
Right. So certainly, and hopefully,
as new parents.
Hopefully, most new parents are on that upward trajectory, and but we do get people sometimes. They say, "Well, should I be doing, for example, estate tax planning, because we don't have a million, we don't have $1 million, or we have a very small amount of funds, but, someday we hope to have that, or we don't know what the future holds. So how do you deal with that? And that sort of goes back to the other question, which is I don't think that you necessarily ever in a situation where you need to wait to do estate planning. You can do estate tax plan. There's not going to be any disadvantage of doing estate tax planning now if it's something that you think may be relevant in the future. But you also just also might not want to be paying for estate tax planning if you don't think that it is relevant. So I think that you can, like I said, put something in place, even if you feel like in the next 10 or 20 years your situation might be different, because in general, most estate planning attorneys recommend that you review your plan at least every 10 years. So do the plan for your situation now, and then, like I said, look at it again in 10 years, because often, too, the people that you're appointing as fiduciaries might change. Like I said, when children are grown adults, that might also change things. So plan for what you have now, but also hopefully come back and review that every 10 or so years.
What if one of the partners or spouses have a family trust from their side of the family?
Sure. So this is another question that we hear in terms of people think, oh, well, I already have a trust set up. My parents already set up a trust, or my parents have already done estate planning for the family, so they feel like maybe they don't have to do any type of estate planning for themselves, that it's sort of already taken care of. And in most situations, actually, it's the reverse. If there is, trust involved in terms of your family has set up certain estate planning documents, it's actually even more important that you be meeting with an attorney to coordinate that with your personal estate plan. And also, questions can come up in terms of a lot of different things that can come up. So I would say that regardless, you still have to do your own estate planning, but I think certainly the attorney that you meet with can coordinate with whatever other planning your family has done.
Okay, for some parents, it is hard to figure out how to make time. I think both Sarah and I can attest to that. Is there an easy way to get basic documents in place to be protected?
So it is hard to find time. I think we both agree on that. I think today that there are a lot of attorneys that are more flexible in scheduling. I know, for example, that I'll meet with clients at their homes or on nights and weekends if it works best for them. I can, a lot of attorneys also can do calls now on the phone, or even via Skype, can do initial meetings. So although they still have to, at some point, meet with the person to execute the documents, they don't have document execution via online yet. But it does require at least some meeting. I do think that most estate planners recognize that that's a difficulty today, and they can find ways to make it more easy for new parents. I know some people talk about sort of there's a lot of do-it-yourself programs out there, and whether or not it makes more sense to do that. Of course, as an estate planning attorney, I would never recommend that approach. But I guess what I would just say is that I think that the value that you get from an attorney is not just that they're have a form that they're sticking names into, like a Mad Lib type thing. The value that you get from the attorney is that they are not only talking to you about the estate plan and preparing those documents, but also finding out what documents need to be done, and what, for example, if you have accounts or real estate, how it should be titled, and all of those sort of implementation steps. So there is value in that. That's not what what you're getting from an attorney is just those documents. It's really the bigger picture. I always talk about this one situation that I had where a client had done their own trust, and it was a pretty good trust that they studied up and read all these books about how
They were not a lawyer?
They were not a lawyer, no. So they, decided that was what they were going to do is drop their own trust and study and read about it and do all of this. So had obviously too much free time. But they drafted this trust, but the problem was that after they had passed, they hadn't put anything in the trust. So it's just sort of an example of how even if you have the right documents or, if you can do them yourself, if you don't implement them in the right way, then you're just the same as if you hadn't drafted it at all.
As you were saying that, something came up. I was thinking about, young people, they're in startups and corporations and working and, in an office a lot, some have work from home, but this office, it would make sense, I would feel like, to partner with, attorneys to offer this service for young parents who have gone back to work and trying to figure out, they offer life insurance policies, they offer these things. It would be really nice if you could have kind of sit down.
Right. Yeah. I don't know if I don't know if there are employers out there that do it, but yeah, it is sort of, it goes through that all those other basic things that you should be thinking about. It is just one thing, and obviously there's sort of value to everyone. It's not just the values to you, the values to everybody else that when they're trying to, whatever it is that something were to happen to you. So
yeah, definitely, it's like your own version of 401k planning. Okay, let's see what's next here. So how do I choose a guardian? For example, I'm thinking of appointing a parent, but worried that he or she might be too old if something happened in 10 or 15 years. Definitely a question I've thought about a lot too.
Right, and actually I feel like this is the one question that often prevents people from getting their estate planning done, because they start to talk about estate planning, they make all the decisions except for who's going to be the guardian, and then it just never gets done. And one thing to keep in mind is that if you don't pick a guardian, that doesn't necessarily mean that there's not going to be a guardian. It's just that you're not going to have potentially any say in it. So, so again, it is a process by. You can always change it. A lot of the times we have people that will put in somebody. For example, when they're a young parent, they might feel like their parent is the best person to do that, but they can put in alternates. So if the parent feels like if something were to happen, they don't feel like they're capable of taking on that role, that they could always, give it over to the next person sort of in line. Or it's something where the person could always, if you're picking a list of people, you can always change it too. You can always come back in 5 or 10 years if things have changed, if the health of people on the list have changed. So to be clear, you don't have to just name one person. You can name one person and then an alternate or a second alternate. We've had people name 3 different alternates. So there is some flexibility there. I also will add on this question, which this wasn't part of the question that we received, but I know that something else that people will ask is whether or not you should name the spouse as well. So, for example, if you're naming your brother or sister, should you also name their spouse, both of them as guardians, which is an interesting question. Yeah. And usually I say if you're naming, if it's really your sister or your brother that you are appointing, there's really no need to name the spouse as well. You don't want it to be confusing, or I would ask that person, if something were to happen to your sister or brother, would you still want the spouse to be the sole guardian? So that's just something to think about, that it doesn't, even though, of course, if you did appoint your sister, the spouse would be involved, assuming that they're still married, that's something to think about, whether you want to name both of them or just name that one person that you actually do want to be serving in the role.
Yeah, do you sort of have a list of questions of ways for people to think about how to choose that guardian? Like, do you have ways to, it might be really complicated for some people to think about this, or, one spouse says, I want my brother, and one spouse says, no, it has to be my sister, and, how do you sort of walk clients through that?
Right, so it's a really difficult question for everybody to make that decision. And I know that one of the things that often comes up is, for example, if there's a person that they really want to serve as guardian, but that person, for example, lives in California, and then there's a person that lives close by, but maybe that person's not as ideal. And so the question is, well, like, do I want to move the child over? And again, this goes into like all the stuff that you really don't want to be thinking
Absolutely.
about. So yeah, so I mean, I can't really make that decision in terms of what's more important. I can just say first that it can be a evolving thing that's changing. I know also that sometimes people like to do like a letter to their guardian, which would say, for example, if there is, if both parents feel like I want my brother and, for example, I want my sister, I want them both to be very involved in the person's life, just to say that this is important, that both of these people be involved, that, that I would want that person, and even if it's not something that's legally binding, just because then they feel like it at least incorporates the family members and they all would feel important, and not that you're just choosing one person. So that's something that I do see clients often do.
Do I need to put assets in the trust while I'm living? Maybe it goes back to your other.
Yeah, so I think we talked about that. Talked about it briefly. So you don't have to put assets into the trust while you're still living. If you, for example, prepare a trust and you have a will that says all of my assets that are not in the trust while I'm living should then pour over. So basically, as long as you have your estate plan set correctly with a pour-over will, you don't necessarily have to fund it. But certainly in the situation where you don't have that other piece of the pour-over will, you do have to fund the trust. And in addition, some of the benefits of the trust involve the assets actually being in the trust. So, for example, the probate avoidance. You wouldn't avoid probate if you leave the assets out of the trust and just let the will pour them over. So there's, depending on the situation, which is obviously an attorney's favorite thing to say, is it depends. But it's a good thing to think about, like I said.
But I mean, I think that's really nice. I mean, we never want to be treated like color by number, or
Right.
This is the way. This is what they say to do in the book, and this is, everybody is unique. And so I think, kind of creating that bespoke, that your estate, your bespoke estate that makes sense for your family, for you, is really, really important.
Right, and I do think, and it does really depend on the person. I mean, I've had people where it's really important for them to put everything in the trust because they want to make sure that, to make it as easy as possible, for example, for their heirs, that everything's all set up. And then I have other people that are saying, well, it might be more convenient for me to have the assets in my individual name versus in the trust, which is something that I talk to people about. And they're like, my heirs can figure it out. So it really depends on your situation and sort of what is most important to you. But there's a lot of different ways that you can do it.
Well, you definitely don't. You want to avoid some of the fighting, because I know that at the end of the day,
Right.
money can be very, can be a hot button issue.
Right. So yes, any ways that you can do it to make it to avoid as much conflict as possible.
Absolutely.
Yes.
Okay. Let's see. Do we have any more? No, that was it. So let me take a look, see if there's any questions that came up. I know there were questions that came up for me as I was doing it. So let's see here. It's a little hard for us to read this, but we will try. Is it complicated to name a guardian who isn't in this country? For example,
It says grandparents in another country.
yes, but it won't let me scroll down. But yes, we'll go with that.
Sure. So that's a good question, and so I would say that that you should choose the best person for the role of guardian. So so certainly when it comes to, for example, powers of attorney, naming a personal representative of a will, for example, or an executor, that can be more complicated if the person is outside the country in terms of signing things or whatever needs to be done in terms of administering the estate. So I do think it can be more complicated. But in terms of a guardian, I mean, yes, it can be a little bit more complicated, but if that's the person, that is the best person to you feel is the best person to serve as the guardian. I don't think it should be something that would prevent you from doing that.
Okay, so this one was easier to see.
Sure.
The system's a little clunky, but what are special considerations for parents that are not married? That's a great question.
Sure. So for parents that are not married, those are definitely people that you would want to meet with an attorney to do your estate plan, because there are special considerations, including one of the things that is just coming to mind is the fact that if one spouse were to pass, for example, should the assets go to the children, or should they go to, sorry, I said one spouse, but in this case they're not married. If one of the parents were to pass, would they want the assets to go to the other parent, or would they want the assets to go to the children? So that's just, that question alone would be reasons why you would want to have some sort of estate plan in place, because the answer to that isn't necessarily clear how you would want assets to pass. Whereas if you are married and there's two spouses, the spouse has some automatic protections and is has certain entitlements because they're married, which an unmarried parent would not have. That one we've already done.
Oh, we did that.
Yeah.
So how do they treat assets that still have outstanding liabilities attached to it, i.e. a mortgage?
Mm-hmm.
Do they only count the...
I think what it's saying, I'm thinking that this is regarding estate taxes.
I don't know why it's not letting us read the rest of it.
How do they treat?
Do they only count the current equity in the property only?
Okay, so if this is with regards to estate taxes, so for example, if you buy, I think this is the example, you buy $1 million house, but you still have a $500,000 mortgage on it, are you going to owe estate taxes? So yes, so they definitely count the mortgage. There is a deduction for that. So in that case, you wouldn't have an estate tax due if that was the only asset.
I think that's it, because this is a little hard to read. If I did miss it, I'll take a look in the follow-up, and I'll send it to you. But it's seemingly hard to see if we've answered everything or not. So I just want to say huge thank you.
And the contact information there is too, and if there are additional questions, feel free to email.
Exactly, and then also Sarah provided her telephone number.
Yes.
It's her direct line. So thank you, Sarah. Seriously, I feel even a little bit more relieved formulating updates to my game plan as you talk. So I think we can all do this. It's really not just about us, but really making a plan for our families and protecting our families and their futures, and not just ours. So. Please continue the conversation and don't hesitate to reach out, and thank you again for taking time out of your very busy days.
Thank you.